or
I believe this is courtroom 2, gentlemen?
Yes.
Yes. Yes.
okay. Give me 1 second.
All the way around.
How's everybody?
All the way around. 1 minute, 1 minute.
Okay, not okay.
Still around.
All right, are we ready to begin at courtroom 2?
Attorney Cook is, but I can't speak for the institution.
Okay.
No, they're lining them up.
A lot of people on here, so let's get cracking if we can. Is there an add-on calendar today?
Not that I know of, Judge.
Okay, thank you.
You're
What's
welcome.
What's my reset?
September the 3rd.
Okay, are we ready at courtroom 2?
Yes, we're ready. I'm sorry, we're ready.
All right, and can everyone hear me so I can give them their rights?
Nothing on here?
All right. Good afternoon, everyone. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I'm Judge Melanie Williams, and today is August 19th of 2024. This calendar is for those individuals who've been recently arrested, but the cases have already been formally accused by the Solicitor General and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. As you can see, I am conducting this hearing by video. It's being live streamed and recorded. That means any member of the public can log on and watch this. When I ask if you understand your rights, that is what I'm referring to. Those who receive a signature bond will be reset for the notice. Those who receive surety or cash will be reset to the all-purpose calendar on September the 3rd, whereby aspects of the case can be revisited at that time. Have all defense attorneys had the opportunity to speak with their clients?
Yes.
All
Yes,
right.
sure.
And are we expected to need interpretation today? All right, hearing none. Who do we have first?
We can start with ACDC.
All right, who do we have at ACDC?
Position number 10, Your Honor.
Thank you. Good afternoon. All right. All right. Are you Ms. Gaspon? Vaughn, I'm sorry if I'm saying that correctly. Your case is 24CR005804C. In this case, you are charged with battery family violence. You understand your rights? Can she hear me at ACDC?
I think she needs to unmute her microphone.
Yeah.
Can you type thank you?
Thank you.
Yes.
Can she hear us?
Yes, I can hear you.
All right. Do you understand your rights today?
Yes.
All right. Thank you. Ms. Hardy?
Good afternoon, Your Honor. This defendant does not have any history to report at this time.
Okay. Thank you. All right. Ms. Desiano?
Your Honor, this incident took place on August 17th of this year. Officers responded to a domestic dispute at 6050 Tangled Tree Drive. The victim in this case is the defendant's husband. His name is Nasser. I apologize, I'm going to mispronounce this. Salamanzda. He advised that the defendant was throwing items around their closet and knocked over a rack. In the scuffle of all that, the defendant pushed him and scratched him on his chest. He believes that the defendant was upset because he was speaking with her sister about some of their marital issues and asking for advice. The defendant also sustained a scratch. However, she told police that it was self-inflicted. Our office has been in touch with the victim today, and I believe he's also on the Zoom, Your Honor. He states that they've been married and for quite some time. They share 3 children together. He says this whole incident was a misunderstanding. He doesn't believe that the victim or the defendant intended to hurt him. He states that this has never happened before. He's not in fear of the defendant, and he would like to continue contact. He would like the defendant to return back to the residence. Judge, this is her first arrest, and given that these parties have been married for a long time and has been no incident, the state doesn't find that this is a high-risk situation where this defendant is dangerous to this victim. So the state's requesting a signature bond through pretrial services, no further violent contact with the victim, taking complete 1 day of anger awareness, no weapons, drugs, or alcohol out on bond. And if the court can sound for Mr. Nasser Salamanzda. Again, I apologize if I'm mispronouncing.
Okay, sir, if you wish to make a statement, Mr. Salamanzda, please raise your right hand and unmute. And you're still muted. You're still muted. Very quickly, please unmute.
Okay, I'm unmuted.
All right, do you swear and affirm testimony you give today be the truth to the best of your knowledge?
I do.
All right, you can put your hand down. What I'm concerned with today is your desire for contact and any concerns you have for your safety. The facts of the case are not of critical importance today, as the defendant is entitled to a bond and will get one. I just want to know your perspective. So very briefly, with those instructions in mind, what would you like to tell me?
So no, I'm not in no danger. I think what the whole thing kind of blew out of proportion when the police officers showed up. I still do not believe that my wife had any intentions of harming me. And I'll be honest with you, I'll do whatever at this point. And because I honestly want her back home, because as she had said earlier, we've been married for 20 years. It was an argument. It just kind of boil over to that.
Okay, that's sufficient. Thank you. Counsel, I'm sorry, your name, sir? I don't think I've met you before. I may have.
Good morning. Once or twice, Judge. Kyle Costa here on behalf of Ms. Gosbin. Yes, we're grateful that the state.
Okay. Do you object to a signature bond through pretrial at level 1 with a 1-day anger awareness course and no further violent contact with the alleged victim?
No, Your Honor, not at all. Thank you.
All right. Defendant will receive a $2,500 signature bond through pretrial services at level 1. She's going to take a 1-day anger awareness course, and she is to have no further violent contact with the alleged victim in this case. She will be reset further notice. Is there anything additional?
No, Your Honor.
I would say that alcohol and those things were not an issue at this. I don't know if she's required to do those things on level 1.
I'm still going to put it in just for now. All right.
I understand. Thank you, Your Honor.
All right.
Can I
Ms.
give the
Strong?
spelling of the attorney's last name, please?
Yes, ma'am. Koester.
Thank you.
All
Thank
right.
you.
Best of luck to you.
Well,
Advocate for your
The
case.
judge, will she be able to come home today?
They'll
Yes,
start
I'll-
processing her out. Yes, but I don't know exactly how long
I'll
it will
do
take.
that
Okay.
side.
Was that known
Okay,
as us?
great.
Okay.
All right. Thank you.
Thank
Best
you,
of luck. Now,
And
I'm sorry. Can we take Attorney Lasala's client?
I'm coming up.
We have position number 18, Mr. Martinez.
Is that Mr. Lascala's client? Yes, no?
It is.
It is. Is Mr. Lascala present? Maybe we can't take this. Mr. Lascala, are you there? Okay, I don't think we can take this. I was trying to help him get out of here. Can we take another position?
Yes, we'll go with position number 16, Ms. Malone.
Okay. All right. All right. Your case is 24 CR 005817B. You are charged with battery. Do you understand your rights?
Yes, ma'am.
All right. Can I have the history, please, Ms. Hardy?
Excuse me, this defendant's last arrest was June the 14th, 2024, out of Fulton County for criminal damage to property. That case is open and she's being supervised by pretrial. Will be surrendering that bond. The case number is 24 PI 004293. She has a total of 8 arrest cycles, no convictions, nothing further.
Thank you, Ms. Allen. Oh, and I'm sorry, Ms. Desiano, please proceed.
Your Honor, I'm showing that she does have a conviction for simple battery from February of 2023 and 21 CR 005796, where she punched her friend in the face. This is a situation that happened on August 8th, Judge, at the Burger King at 5066 Old National Highway. An officer observed 2 people having a verbal dispute outside in the Burger King parking lot and stopped to investigate. The officer spoke with a witness who was on scene who stated that the victim in this case, whose name is Alfredo Guzman, he went to the bathroom and knocked on the bathroom door and then walked away after he realized it was occupied. The witness then told the officer that the defendant came out of the bathroom very upset, accusing the victim of trying to open the bathroom door. The victim then walked outside of the Burger King in an attempt to de-escalate the situation, and the defendant followed behind him and had a brush in her hand and struck him in the face with the brush. The victim sustained a laceration to his head, and then the defendant also threw a bunch of rocks at him, and the parties started fighting at that point. The officer also interviewed some of the employees at the Burger King, the defendant and the victim, and determined that the defendant was the primary aggressor. In this case, Your Honor, considering the Ayala factors, the risk of reoffense is high. This defendant just previously pled to simple battery and looks like she just finished probation for that. There's also a concern that she won't show up to court. There's an open felony FTA in this case, and then of course her open felony for damaging property that's also an FTA status. The state is requesting in this case, Judge, a $2,500 good bond, no further contact with Mr. Guzman, a stay away from that Burger King, taking complete anger management course, a BHET, and no weapons, drugs, or alcohol while out on bond. Thank you.
Thank you. Is Mr. Guzman online? All right, who represents this defendant? Is that you, Mr. McLean? Mr. McLean, you're muted. We can't hear you.
There we go. Okay. Sometimes it goes to this safe driving mode. I don't get that. Your Honor, they do qualify for the public defender. Right now, it looks like there's a bond set on it. We would ask the court to consider lowering that bond to $1,000 surety at the most, but a signature bond if possible. It does say, 79% chance of 79% likely to appear. So I've seen worse. This will be contested at trial.
Thank you. Defendant will receive a $1,500 surety bond. Stay away from that Burger King location. Have no contact for Mr. Guzman. Have no alcohol, no drugs, no weapons as a condition. Is there anything additional?
No,
That's
Your
all.
Honor.
All right. Best of luck to you. Who do we have next?
No, it's not. We're gonna go back to position number 18, Mr. Martinez.
Oh, Mr. LaScala, are you back? Are you here?
I am. I'm sorry, Judge. I had to sneak out for
That's
just 1 second. Nice to
That's
see
okay.
everyone.
All right. Your client is.
Martinez, Derek.
I'm trying to get it up. Okay, Mr. Martinez, your case is 24 CR 005818Y. You're charged with obstruction, reckless driving, defective headlights, fleeing, misrepresenting a tag, all with the offense date of August the 18th. Do you understand your rights today?
Yes, ma'am.
All right, Miss Allen.
Are we going to hear from pretrial about criminal history?
Oh, that's right. I'm sorry, Miss Hardy.
Thank you.
Okay, this defendant has one adult arrest cycle out of Ohio. And it resulted in a felony conviction for robbery. Nothing further to report.
Okay, Miss Allen, now we're ready for you.
Thank you, Your Honor. We have moved forward on 6 of the counts that this young man came in with. I am bad at math, but I think that means some NODs were done and they should have been received. This is a traffic stop or an attempted traffic stop on the 18th of August, Your Honor. Police saw a Chevy Camaro with a fake tag on the back, written, looked like a kind of vanity plate or an ID, maybe even a name tag. The report states that this individual had just been at like a racing event or car showing off event. It was also this Camaro being driven by the defendant was driving with no headlights or taillights. Officers attempted to initiate a traffic stop with sirens on. The defendant fled and then was seen to spin out on an on-ramp nearby and have an accident. Police canvassed the area for the defendant and found him on foot running on the shoulder of the highway. He was directed to stop and get on the ground. He continued to run and then was detained. He began denying that he was the driver of the Camaro. He had no license on him. While on scene, officers were informed that he'd actually struck another vehicle before he came to rest on the side of the road. What initially was thought to be a single car collision was actually a collision involving another vehicle. The victims of that other vehicle ID'd the defendant as the person who'd been in the driver's seat and who had exited the vehicle after crashing into them. I would note that this defendant was seen driving recklessly, crossing multiple lanes of traffic, what would be or could be described as racing or laying drag, although we have not moved forward with that charge, Your Honor. But we did move forward with a reckless driving charge in this case. In this situation, we'd ask for a $6,000 surety bond. That's $1,000 on each count. No driving.
Count, Miss Allen, or is it 5?
It's 6, I believe. Look.
It's 5 on the calendar, but 6 actual.
No, you're right. Wait, hold on.
1, 2, 3, 4.
6.
I think well, I see 5. 1 obstruction, reckless driving.
Charge has 2 cases, 2 charges. The attempted to misrepresent.
Oh, okay. I got you, Miss Holly. Thank you.
You're welcome.
Okay, so you want 1,000 on each?
Yes, Your Honor. No driving unless licensed and in a properly illuminated with headlights, tags, vehicle, and has his license on his person. We'd also request a driving course, the one that is not maybe related to DUI. I don't remember what it's called. Anybody? Defensive driving?
Defensive driving.
Yes, thank you.
I knew what you meant. All right. Mr. LaScala, please.
Judge, thanks. My client is 19 years old. His father is Ruben Martinez. He is on the call this morning or this afternoon. Judge, I couldn't disagree with the facts more. I don't know how he was identified. There's none of that is in the warrant. I don't know if it was a show up. I don't know if it was a photograph. I don't have a clue. But one thing that we do agree on is that he has never admitted to driving this. He begged the police officers to dust the car. A driver's license was found at the scene. It wasn't his car. It wasn't his driver's license. He was a passenger in this vehicle. So we do anticipate fighting the charge. I think a lot of these charges are duplicative. I think this a reasonable bond around $2,000 would be fine. But if the state's wants the 6, I understand it. But ultimately, this is going to be a trial.
Okay. What we're gonna do? Let's think about this. Okay. I'm gonna give him a split bond. On the obstruction, it's gonna be $1,000 surety. On the reckless, that'll be 1,000 surety. On the driving no headlights, that's a signature through the jail. On the fleeing and attempting, that's 1,000 surety. And on the remaining two charges, those are 1,000 SOB through the jail. So 3,000 SOB, 3,000 surety. I'm not gonna fully restrict him from driving, but in light of his age, he's gonna take the Alive at 25 class.
I'm familiar with the judge.
Okay, all right, so he's gonna go ahead and enroll in that as a condition.
Okay.
All right, is there anything additional from State or Defense?
No, not for the defense. Thank you.
Thank
All
you.
right.
Oh, I'm
Best
so
of-
sorry. Could I just get the accusation number one time, please?
Let's see, he is 24 CR 005818Y.
Thanks a million.
All right, Mr. Lascala, you're free to go. Have a good afternoon and
Nice
best
to
of
see
luck
everybody.
for your
Take care.
13. All right, bye-bye. Who do we have next?
Next we have position number 22, Ms. Torici.
Okay. Mr. Ricci, I'm sorry if I'm saying it incorrectly. Your case is 24 CR 005808J. You're charged with simple battery and criminal trespass. Do you understand your rights? All right, Ms. Hardy.
The last, excuse me, the last arrest for this defendant was August 15th, 2016 out of Santa Ana, California for driving under the influence of alcohol or drugs. They have a total of 4 arrest cycles, arrests out of California and Georgia, misdemeanor convictions in 2009 and 2016, both for DUI. Nothing further to report.
All right, Ms. Allen.
Thank you, Your Honor. This is an incident that actually occurred on the 29th of June, 2024. This simple battery charge is basically the defendant throwing an alcoholic beverage in the face of a ex-colleague. At 2:05 a.m., police were called to the Gaslight, which is a supper club, it likes to call itself. It's a restaurant in Roswell. That's 890 Atlanta Street. There they were responding to what was described as a past disturbance. Security at the location reported that the ex-manager, the defendant, Ms. Torici, in front of you, had been fired the day before and told not to return. She, in fact, came to the location that evening on the 29th and began arguing with an ex-employee there, or another employee, an ex-colleague of hers. This exchange was observed by security. This verbal became heated. The defendant was seen to be heavily intoxicated. Security reported that he escorted her outside, and while he was standing between her and the young woman who she threw a drink in the face of, the defendant threw the drink in the face. And surveillance captured this incident. There were text messages sent to the security guard by the defendant saying she's so sorry, she didn't mean to throw alcohol on him. It was meant for the victim. The victim in this case, her name is Shahraz, Shahraz, last name Pirali, Pirali. She's a current employee at the location and the niece of the owner. We've been in touch with her. She said that she corroborated the information, Your Honor, in our documentation and confirmed the events. She said that the defendant came to the location trying to fight her, but security stepped in, thankfully, and that there'd never been any problems in the past with this individual. She wants no contact, and obviously we're asking for her to stay away from the property. There's a criminal trespass charge because it specifically states she'd been told not to return, and she came back to the location. Police were called and told that this was someone related to a past disturbance. Also of note, Your Honor, every arrest and every conviction for this defendant is related to alcohol. She's described as being heavily intoxicated during this incident. So we would be requesting a $2,000 surety, no contact with the victim in this case, stay away from the location, no drugs, alcohol, or weapons, and submit to a substance abuse evaluation and treatment, follow through with any recommendation. Thank you.
All right, is Ms. Pirali on the line? I wish to make a very brief statement.
I believe she's at work.
Okay. Mr. McLean?
Yes, Your Honor. I understand what the state is saying about alcohol, period, but let me point out nonetheless that the DUIs were successfully completed as to all their requirements, and there's been no problem with them. Your Honor, given that this is one count simple battery, she has a stable address, she has stable phone numbers, emergency contacts, the whole 9 yards, local. Local now. We would ask the court to consider a signature bond.
All right, defendant's gonna receive $1,000 surety bond, 500 on each count. She's to have no contact with the alleged victim, stay away from that location, and have no alcohol, no drugs, no weapons as a condition. Is there anything additional?
Nothing.
All right, best of luck to you. Who do we have next?
We got position number 25. Ms. Zambrano.
All right, good afternoon. Your case is 24CR005813E. You're charged with 2 counts of battery family violence. You understand your rights today? Is that a yes? All right, Ms. Hardy.
The last arrest for this defendant was September 6, 2020, out of Gwinnett for a DUI. That did result in a misdemeanor conviction for DUI. They have a total of 2 arrest cycles in Georgia. Nothing further to report.
All right, thank you. Ms. Allen?
The second arrest, Your Honor, is 2018 out of Gwinnett County, and that was a simple battery family violence case that was eventually dismissed. So this is the second violent arrest in this young lady's history. The charges in this case stem from an incident on the 18th. So yesterday, Sunday, August 2024. Police were called to apartment 546. This is 1133 Huff Road Northwest at about 4:30 p.m. There they spoke with the 911 caller. The defendant's name is Joshua. The victim's name is Joshua, common spelling, and his last name is Dierberger, Dierberger. He reported, he was seen in the hallway of the location as police were approaching, and he had visible bloody injuries to his face. He reported that there'd been a verbal altercation. He was frantic and obviously upset in the hallway, reported himself as the 911 caller and said the individual, his girlfriend who assaulted him, was in the residence. Police knocked on the door of the residence, and the defendant answered the door. The defendant and the victim were separated and made statements. The victim, Mr. Joshua, reported that there had been a verbal argument over who was going to take the dog outside. The defendant actually took the dog outside, and at that point, he packed his belongings and was going to take a moment to leave. But first, he went to go smoke a cigarette. And so when he went outside, I think into an elevator, he encountered the defendant, who then assaulted him in the elevator. He was seen to have bite marks on his arm, on his left arm, abrasions on his collarbone, abrasions in the middle of his forehead, an abrasion under his left eye, and bruising to both eyes, which looked like they were about to just look like black eyes. He reported that he'd been struck multiple times by the defendant with her hands, open and closed fists, all over his face and his body. And obviously he was bitten. He reported being bitten, and there was a mark on his arm. The defendant was spoken to. She said that there was an argument about the dog, and that when she was going to take the dog outside, he grabbed her arm. She left with the dog, and then they met in the elevator, and he attacked her. However, she had no injuries visible to her. They were living together, and the victim in this case reported prior violence, Your Honor. Based on the prior arrest, the obvious visible injuries to this victim, we have not been in contact with the victim today, and also based on that, we're asking for a $4,000 surety, Your Honor. This defendant has 2 counts of battery family violence in front of you. We'd ask for no contact and stay away from the incident location, no drugs, alcohol, or weapons. We'd also ask that the defendant be ordered to start FVIP, or at least complete some anger management. There's a risk to reoffend here, a risk for the intimidation and tampering with witnesses. This is a safety issue, Your Honor, and so we'd ask for no contact until someone can meet with the victim, and if that victim would like a modification, they can let the court know and come and appear in front of the court. Thank you.
And his name was Joshua?
Joshua Dierberger, Dierberger.
All right, is Mr. Dierberger present and wishes to make a statement? Hearing none, Mr. McLean?
Your Honor, while the court might be, I'm not trying to put thoughts in the judge's head, but while the court may be leaning towards or may be considering anger management, we think it would be appropriate to actually order the DVIP, but that's, of course, people are free to take it if they want to, but as a court order, we think that would be premature at this time. Your Honor, given the history and given these particular facts, we would ask the court to consider a signature bond or a lower than 2,000 in the surety bond area.
All right. The defendant is going to receive a $1,500 surety bond. That's 1,000 on count 1, 500 count 2. She's to have no contact with Mr. Dearberger. Did the state request to stay away? I'm assuming so. Stay away from that location.
Yes, Your Honor.
And she's to have no alcohol, drugs, or weapons. And as a reminder, she'll be reset to all purpose on the 3rd of September. All right, that concludes this case. Best of luck to you. What do we have next?
Position number 8, Mr. Franco.
Okay.
What position is that? I'm sorry.
8.
Thank you.
I'm trying to scroll there. All right, Mr. Franco, your case is 24 CR 005809C. You're charged with battery, family violence, and cruelty to children in the 3rd. You understand your rights?
Yes.
All right. Can I have the history, Ms. Hardy?
This defendant does not have any history to report.
All right. Thank you, Ms. Sessiano.
Your Honor, this incident took place on August 18th of this year. Officers were dispatched to 395 Robin Court in reference to a woman who had questions about filling out a police report. That was the victim in this case, Alexa Franco. She's married to the defendant. She told the police that she was arguing with her husband when he pinned her against the wall and squeezed her arm, leaving a swollen red mark. This happened at the party's marital home in the presence of the party's minor child, initials LF. We have been in touch with Ms. Franco today. She states they're married, they live together. She states that she was trying to get her car keys and that the victim, the defendant said she could not leave with their son and pinned her and squeezed her until she released the car keys. She states that their 1-year-old was present during this altercation. She states, although this is his first arrest, this is not the first time that the defendant has been violent towards her. She states this is the first time that she's involved law enforcement. She's currently filing for a TPO. She's in fear. She does not want to have any contact. She doesn't want the defendant to have contact with the child at this time either. She states that she would like the defendant to stay away, and he'll need a one-time law enforcement escort to retrieve his belongings. Your Honor, the state's requesting a signature bond through pretrial in this case, no further contact with the victim, a stay away from the residence, taking complete anger awareness, no weapons, drugs, or alcohol while out on bond. And I believe Ms. Franco is on the line.
All right, Ms. Franco, if you'd like to make a brief statement, you are not required to, but if you wish to, this is your opportunity. I need you to turn on your camera, raise your right hand. All right, do you swear and affirm testimony you give today will be the truth to the best of your knowledge?
Yes.
All right, what I'm most concerned with is any desire for contact with the defendant and whether you have any concerns for your safety. If you have other facts that you wish to address, they will be addressed at a hearing at a later date. All right, this is just a bond hearing. So what would you like to tell me in light of those instructions?
I think facing some of the consequences of the charges, I am not entirely confident of what his next moves would be, and that I would fear for something to be done, whether to me or him to see his son without approval. And the only correction I do want to make to the statement was it wasn't necessarily me that was trying to leave with the son. It was that he decided to take Leo without discussing things with me, and then came at me when I took the keys, knowing that the car seat was in my car.
Okay, so just to clarify, you do not wish to have contact.
No contact, please.
All right, understood. Thank you. Who represents this defendant?
I do, Your Honor.
Mr. McClain, do you object to a signature bond through pretrial at level 1-day anger awareness and no contact?
We do not object, Your Honor. No contact, stay away. We discussed the stay away concept. If there were to be visitation, the third party transfer.
All right, understood. Defendant is going to receive a $3,000 signature bond at level 1 through pretrial services. He's to have no contact with the alleged victim in this case. However, he can coordinate transfer of the child through a third party. He can return one time to the residence with law enforcement to get any items. Otherwise, he is to stay away from the residence on Robin Court. He's also going to take the 1-day anger awareness course and have no alcohol, no drugs, no weapons as a condition. Is there anything further?
Nothing.
No, Your Honor.
Is
All
this
right. 1,500 on each judge?
I'm sorry, there's 2 charges, isn't it? 1,000 on, I said 3,000, I want 3,000. Wow. I want 1,000 on the cruelty, so 2,000 on count 1, 1,000 count 2. All right, best of luck to you, sir. Who do we have next?
Next, we have position number 14, Mr. Johnson.
Yeah, come on.
Oh, I'm sorry.
All right, Mr. Johnson, your case is 24 CR 005816E. You're charged with simple battery. You understand your rights? Is that a yes? Ms. Hardy, please proceed.
The last arrest for this defendant was May the 16th, 2022, out of Denton, Texas, for unlawful carrying of a weapon and possession of marijuana less than an ounce. That did result in a misdemeanor conviction. They have that 1 cycle out of Texas. Nothing further to report.
All right, thank you, Ms. Desiano.
Your Honor, this incident took place on August 8th of this year. Officers were dispatched to the BP at 1400 Donald Lee Howell Parkway regarding a battery. The victim in this case is the clerk at that store. His name is Vamsi Dupalla, Dullipalla. He advised that the defendant is not welcome in the gas station. He saw him outside of the gas station and approached him and told him that he's not allowed to come in. Then the defendant removed his shirt and started punching the clerk. The defendant fled the scene after this incident on the 8th, and then the clerk called 911 yesterday because he saw the defendant and he was apprehended at that time. We have been in touch with the victim judge. He's an employee at the gas station. He states that this defendant comes to this property often to shoplift, although there's no criminal history of that. He states he wants no contact and wants him to stay away from the property. Your Honor, this is his first arrest in Georgia. His other arrest is relatively minor. The risk to the public is low. The state's requesting a signature bond through pretrial services, no further contact with the clerk, stay away from the incident location, taking complete anger awareness course, no weapons, drugs, or alcohol while out on bond. And if the court can sound for the victim, Vamsi Dulipala, I believe.
Is Mrs. Dulipala present, wishes to make a brief statement? Hearing none. Mr. Cook, do you object to a signature bond through pretrial at level 1 with the stay away, no contact, and 1-day anger awareness?
We would object to, we would ask for a signature bond through the jail and we would object to the anger awareness. If you read the warrant, it appears that the store worker pulled a gun on my client. I don't know what to do when somebody pulls a gun on you, but there's no history of a criminal trespass warning or anything of the like. So.
All right. Defendant's going to receive a signature bond through pretrial at level 1. He is going to take that 1-day anger awareness course. Have no contact with the alleged victim. The signature bond will be is it 1 charge or 2? It's a $2,000 signature bond through pretrial at level 1. No contact with the alleged victim. Stay away from that location. Have no alcohol, drugs, or weapons. And he is going to take the 1-day anger awareness course. Anything additional?
No, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Next, we have position number 20, Mr. Nelson.
Okay, Mr. Nelson, your case number is 24 CR 005805A. You're charged with 2 counts of battery family violence and 2 counts of cruelty to children, and a third with the offense date of July the 14th. You understand your rights?
Yes.
All right, Ms. Hardy.
The last arrest for this defendant was November the 4th, 2008, out of Clayton County for reckless driving and unauthorized discharge of a firearm within 50 yards of a public highway. They have one Cycling, Georgia, a misdemeanor conviction in 2010 for reckless conduct. Nothing further to report.
All right, Ms. Allen.
Thank you, Your Honor. This incident was on the 14th of July, between 5 and 6 p.m. Police responded to a dispute call at 1705 Wilma Drive. There, the victim reported that there had been an incident earlier in the day. She was caring for the children that she and the defendant share. They're actually twins, and they were infants born February the 5th, 2024. The victim reported that during this verbal argument where she was asking for help with these small children and talking about the fact that help from the defendant was not forthcoming recently, he grabbed her and threw her on the bed, punching her multiple times. She was seen to have bruising on her left arm. The victim also reported that the defendant started throwing items, including a laundry hamper, at her, and the laundry hamper actually struck one of their 5-month-old twins, Olivia, in the head. Olivia was seen to have swelling to her left eye area and a small laceration. The defendant had fled the location. So we've got 2 counts of battery, family violence, and 2 counts of cruelty in the children. 1 battery is against the child. Cruelty in the children counts are for the fact that there were 2 children present while their mother was being assaulted and punched, causing bruising. We have spoken to the victim in this case. Her name is Melissa Foster. She reported that since this incident, she and the defendant are no longer together and that she's not at that residence anymore. She has had communication with him since, and she reports that there's been no violence. Your Honor, in this case, we would be asking for a $4,000 surety. That's $1,000 on each count. Absolutely no contact with the victim wherever she may reside. And no drugs, alcohol, or weapons. We'd be asking for the defendant to begin family violence intervention, Your Honor, and if a modification needs to be done at a later date, that can be addressed by the court. But at this point, there's a risk to reoffend. There are tiny babies at home. I actually believe that she's at the location and he's moved out. So if we would request to stay away from the Wilma Drive, 1705. But we would ask for no contact at this point until a period of time with some counseling or some classes can be established. I do not believe these individuals are married and these children are not legitimated. So there is no actual right to custody and visitation in this case. We believe the children being such vulnerable age and this incident being so reckless that's what's warranted here. Thank you.
All right, I'm going to sound for Ms. Foster. Ms. Foster, are you present? Wish to make a statement? If
Yes,
so,
I
please
am.
raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes.
All right. I'm going to give you some instructions. What I'm most concerned with are any concerns you have for your safety and whether you wish to have contact with the defendant, whether you want to add to Ms. Allen's statements. That's not what's of critical importance today. There will be other opportunities for you to flesh out the facts. So in light of those instructions, what would you like to tell me?
I did want to state that he has been apologetic towards the situation. He did say he would cooperate in regards to, whatever comes with this, and he is willing to hold himself accountable for the things he has done, and that he stated that he does love his children, and I am aware that it was a mistake. He did not mean to harm his child.
All right. Do you wish to have contact with the defendant?
I do wish to have contact. Like I said, he does state that he will hold himself accountable and take classes and do whatever he needs to do in regards to that. So I'm just hoping that that's taken care of as well.
All right. Thank you. I appreciate you coming to court making the statement.
Your Honor, might I ask a brief question?
Oh, so brief, Miss Allen. I think
Yes.
I've got this. Go ahead. Miss Foster, if you would come back for a brief moment.
Yes, ma'am.
Ms. Foster, when was the last time the defendant was in the home with you and your children?
He has not been in the home with me and the children since the incident. Obviously, because of what happened, I have to make sure my children are
Has he
safe.
visited you in the home with the children?
He has not.
Okay. And when was the last time you communicated with him?
I recently communicated with him. I would say it was yesterday.
Has he called you from the Fulton County Jail?
He has not.
Okay. Thank you. No other questions, Your Honor.
Thank you. All All right, Mr. McLean.
This may seem a minor point, but I did want to point out that the 2008 discharge of a firearm, he was with a group of people. It was election day. There was celebratory firing into the air. Wasn't his gun, but when the police said, your guns are hot, we understand you're firing your guns in the air, but you can't do that. He successfully completed his probation.
What year was that again?
2000 November. So
2008?
right. So it's a very minor point. I just want to say he's not a dangerous person to the public. And that sounded bad to have that in his past, Your Honor. He does agree with the notion of some anger management would be okay with him. We talked about that. If he needs to start some other courses, that I think would be best not court ordered at this time, Your Honor. I'm going to leave it up to Your Honor about the no further violent contact versus no contact at all. We would ask the court to consider a signature bond, however. He does work, and he will be doing his best to continue to provide for the kids. He has a good job doing HVAC, and we don't want to see him lose that job.
Okay. There was 4 counts, correct? Okay.
Yes.
Okay, defendant is going to receive a $2,000 surety bond, $500 on each count. He's to have no further violent contact with Ms. Foster, and he's to have no alcohol, no drugs, no weapons as a condition. Is there anything additional?
Nothing.
All right, best of
Your Honor,
luck.
can we request some anger management?
I'm not going to order it quite at this time. I did give him a surety bond to affirm his return. All right, best of luck to you, Mr. Nelson. Who do we have next?
Next, we have position number 3, Mr. Benton.
Oh, Mr. Benton. All right, your case is 24CR005797G. In this case, you're charged with obstruction, simple battery, and battery. Do you understand your rights?
Yes, ma'am.
All right, Ms. Hardy.
This defendant's last arrest was July the 30th, 2024 out of Atlanta for obstruction, interference with government property, simple battery against law enforcement, and they're on probation for that under case number 24CR005329G. They have a total of 15 arrest cycles out of Georgia. Misdemeanor conviction in 2023 for criminal trespass. 2022 obstruction of law enforcement and criminal trespass. There's also another probation case for simple battery. That number is 23CR004940G. Nothing further to report.
Thank you. Ms. Desiano, please proceed.
Your Honor, this incident took place on August 17th of this year. Officers were flagged down by the first victim in this case. Her name is Essence Tyson. She was at the Checkers at 120 Piedmont Avenue and flagged down the officer after the defendant approached her and spit in her face. While the officers were speaking with Miss Tyson, another person approached them. His name is Mr. Gutierrez Aguayo. He reported to the officer that the defendant was running down Piedmont Avenue toward Auburn Avenue and randomly walked up to his girlfriend and struck her in the face. And that's the second victim, Your Honor. That's Miss Rosalinda Rios, causing a visible laceration to her face. The officers saw the defendant running toward Auburn Avenue. And once the defendant realized the police were chasing him, a longer foot chase ensued and multiple commands to stop running were ignored by the defendant. Your Honor, he's been arrested. This will now be his 3rd offense in the last 30 days. He was arrested originally on July 20th for a simple battery, and then he was given an SOB and then released and arrested on the 30th, 10 days later, for simple battery against a law enforcement officer and willful obstruction and interfering with government property. He pled to both of those cases last week, Judge. He hasn't even been out of jail a week. And it's a similar type of situation in the case involving the officer. He backhanded an officer who arrested him after he was running in and out of traffic. And the officer was telling him to get out of traffic so he didn't get hit by a vehicle. The second case, Judge, that he also pled to last week was an incident involving a random stranger again, where he was at the Pizza Hut on Piedmont Avenue and spat in the stranger's face when he tried to stop her and she kept walking. And then, of course, he also has an open simple battery from DeKalb County as well from last year. Your Honor, considering the Ayala factors in this case, this individual, plain and simple, is a public safety concern. He's a danger to the community. He is on his fourth victim in less than a month. He's been incarcerated in the Fulton County Jail for most of the last month. And he's been out of jail, like I said, less than a week, and he's already committed more crimes against 2 more people. He has 10 convictions from the 6 different cases in the last 2 years alone. That's not including his open case. The risk of reoffense is high because of his 17 cycle arrest history. And again, this notion that he's just been arrested multiple times. I know on the SAP calendar last week, one of the issues the defense had, we offered a plea and we had asked for a mental health evaluation. And it's my understanding that the defense was objecting to that at that point, and I don't believe Judge Law ordered one as a result of his plea to the simple battery. Your Honor, I would ask today that because now we're in a situation where he's harmed 2 more people, that I would like the court to order an MHET at this point, or at least a BHET to start. The state's requesting an $8,000 good bond, Your Honor, $5,000 on the battery, $2,500 on the simple battery, and $500 on the obstruction. Absolutely no contact with the victims in this case. The state's also going to ask for a stay away from all of Piedmont Avenue at this point because the previous incidents have also happened on Piedmont Avenue. A BHET or preferably an MHET, no weapons, drugs, or alcohol out on bond. And if the court can sound for Ms. Tyson and Ms. Rios.
All right, is Ms. Tyson present? Wishes to make a statement? Is Ms. Rios present and wishes to make a statement? Ms. McLeod?
Good afternoon, Your Honor.
Good afternoon.
I believe an MHET would be appropriate under the circumstances.
All right. Anything additional, Ms. McLeod?
Nothing further, Your Honor.
All right, we're gonna accept the state's recommendation. It's gonna be 5,000 surety on the battery. What was it, 2,500 on the simple, 500 on the obstruction, for a total of 8,000 surety. He's gonna undergo an MHET, stay away from Piedmont Avenue, and have no contact whatsoever with any of the alleged victims, have no alcohol, no drugs, no weapons. And is the 3rd a Thursday? Ms. Strong? I don't know. Let me look.
It's a
No,
Tuesday,
ma'am, it's
Your
a
Honor.
Tuesday
Okay, restate him to SAP on Thursday.
for a comp.
Yeah, well, you don't have to put him on comp yet, but just put him on the Thursday calendar. So he'll
Okay.
start tracking on the competency track.
What? Okay.
All right.
Okay.
All right. Thank you. Best of luck to you, sir. And Ms. McLeod, is that your only case today?
No, Your Honor, I have another.
Okay, can we
Your Honor, can you give me that breakdown one more time?
5,000 battery, 2,500 simple, 500 obstruction.
Gotcha. And that's all surety, right?
Yes.
Okay. Next we have position number 4, Mr. Bernard.
Can we take after this one, Ms. McLeod's next case?
This is my case, Your Honor.
Well, that's yours. Good, that worked out. Okay, Mr. Bernard, your case is 24 CR 00579AG. You're charged with battery, family violence, and cruelty in the third. You understand your rights?
Yes.
All right, Ms. Hardy.
The last arrest for this defendant was September 26, 2023, out of Fulton for theft by receiving and obstruction. That case is open under 24 SC 002712. They have a total of 7 arrest cycles in Georgia. Misdemeanor conviction in 2021 for driving without a license. There's an additional open case, 23 CP 221054. Possession of sawed-off shotgun, machine gun, dangerous weapon, or silencer, and obstruction of law enforcement. Nothing further to report.
All right, thank you, Ms. Sessiano.
Your Honor, this incident took place in July on the 15th of this year. Officers were dispatched to 4639 Tartan Court in Union City regarding a domestic dispute. The person who called 911 was actually the defendant's mother. She told the police that her son and his child's mother were fighting. She did not witness the beginning of the altercation. However, she did hear it and then went outside and tried to separate the parties and took the party's child away from the altercation. She states that she was concerned at the time for her grandson's safety, and she's, to put it plainly, sick and tired of all of the arguing between her son and his child's mother. She's the victim in this case. Her name is Nisha Brown, the mother. I'm sorry, the child's mother, not the mother who called. Neither the victim or the defendant were on scene when the officer arrived. However, another officer was able to make contact with the victim and speak with her. She advised that she told the defendant she was coming to pick up the baby. The defendant was telling her to go back to her sister's house. She went inside the home to look for the child's bottle. And the defendant was following her around. As she was leaving, the defendant attacked her with a closed fist and grabbed her hair. The victim had a visible injury on her bottom lip. Our office has been in touch with Ms. Brown today. She states that they do not live together. They do have that one child together. She states that she was not the only person that got in an altercation that day. She said she was also attacked by the defendant's sister. She states that they've had altercations in the past, but that have never been physical. She states this is the first time the police have been involved and that they've been in contact since this incident without issue. She's not in fear and would like to continue contact. Your Honor, the state, he has a previous case, Judge, from 2020, where it was an aggravated assault, family violence, strangulation. It was dead docketed. It was reduced to a battery, family violence, and then the defendant completed diversion. So of course, it's not a conviction at this point. However, there is a concern that there's a danger to this victim based upon the witnesses' accounts of all of the arguments that have been happening between these parties. The fact that there was this previous ag assault strangulation case that was against a different victim, and now this is the second victim. There's also the risk of reoffending for the same reason. And there's also a concern that he won't show up to court based on an FTA from 2023 for theft by receiving out of Clayton County. The state's requesting a $3,500 good bond, $2,500 on the battery, $1,000 on the cruelty, no further contact with Ms. Brown. The state would also request that the defendant start family violence intervention program, no weapons, drugs, or alcohol while out on bond, and if the court can sound for Ms. Brown.
All right, Ms. Brown, if you're present, unmute and please raise your right hand so I can place you under oath. Do you swear? We need to see your whole. Ms. Brown, are you wearing a shirt? We need you to put a shirt.
Okay. Hold on. I'm sorry. I just got my baby up.
Okay. This is still court. Okay.
Yes. Hold on. Give me one moment.
And Judge, while we're waiting for her to get dressed, as far as contact with the child goes, I don't believe these parties were ever married. And I believe that's something that can be addressed in Superior Court. So at this point, I would ask for no contact. Thank you.
All right. Do you swear and affirm, Ms. Brown, that the testimony you give today be the truth to the best of your knowledge?
Yes.
All right. What I'm most concerned with is desire for contact and concerns for your safety. What would you like to tell me with those instructions?
He's not no harm to me, and I want him to have contact with his child.
All right. I appreciate you coming to court and making that statement. Ms. McLeod?
Yeah.
Was there something else? Go ahead, Ms. McLeod.
Yes, Your Honor. I would be asking for a signature bond for my client, and if the court is disinclined to give him a signature bond for as low a bond as possible. It sounds to me, based on my conversations with my client and also with Ms. Brown, there was just a minor disagreement between the parties. As the state has said, they don't live together, but they do have a child, and this child is 1 year old. It's a crucial time in this child's life. So we naturally would be opposed to my client not being able to have contact with his child. A child needs their father. Whether or not the two people are married is not the issue, because being a parent, being a father, has nothing to do with whether you're married or not. It is all about whether or not you are a part of your child's life. So to cut him off from communicating with his child would, in my opinion, be more harmful to the child than it would be good, Your Honor. So we would ask the court to condition any bond that he has on no further violent contact with Ms. Brown, because she has expressed to me, and she said it here in open court, that she does want to have contact with my client, and that she does want my client to have contact with his child.
Defendant, thank you, Ms. McLeod. Defendant's gonna receive a $4,000 surety bond, $3,500 on the family violence, and $500 on that cruelty. He's to have no further violent contact with the alleged victim in this case, have no alcohol, no drugs, no weapons. Is there anything additional?
No, Your
Honor.
All right, best of luck to you, and Ms. McLeod, you can be excused. Take care. Have a great afternoon.
Same to you, Your Honor.
All right, bye-bye. Who do we have next?
Next we have position number 1, Mr. Beck.
Okay, Mr. Beck, your case is 24 CR 579. I'm sorry, 5795Y. You're charged with simple battery in this case. Do you understand your rights?
Ma'am.
All right, can I have the history, Ms. Hardy?
The last arrest for this defendant was January 14th, 2020 out of South Fulton for simple battery. That did result in a misdemeanor conviction. They have a total of 17 arrest cycles in Georgia. Felony conviction in 2001 for a CWAC charge. 2001 misdemeanor conviction for a CWAC charge. Nothing further to report.
Thank you, Ms. Desiano.
Your Honor, this incident took place on August 17th of this year. Officers responded to 4900 Delano Road, apartment 6E, regarding a domestic dispute. The victim in this case is Angie Coverson. She's stated that she and her boyfriend had an argument about her being out late. Before she could leave the room, the defendant pushed her on the bed and held her down by her neck area. Notably, the defendant denied putting his hands on the victim. However, the victim's son was also present during this altercation and confirmed what the victim had already told police, that the defendant had grabbed her around her by her neck area. We have spoken to the victim today. She states that they're in a relationship. The incident location is her residence, and she said the defendant does not live with her, but does stay with her from time to time. They have no children together. She's saying that he pushed her on the bed and was holding her down. She's now denying that he touched her neck area. She states that they have gotten to verbal altercations in the past where the police have been called. However, there were no arrests made. She states that she's not in fear and would like to continue contact. Your Honor, as pretrial stated, he has a simple battery family violence from 2020 that's against a different victim. He also has an open simple battery case that's in bench warrant status from a failure to appear on October 14th of 2022. That's the same victim as the case where he has a conviction from 2020. It's an ex-girlfriend. He's accused of doing something very similar, grabbing her by the neck and pushing her up against the wall when he didn't like that she was speaking to other men. Your Honor, I believe based on his arrest history, the risk of reoffense is high and a danger to this victim especially and her children. It's not the first time he's been violent in a domestic situation, and he had no qualms of being violent against in front of the children. There's also a concern of intimidation here, especially considering that he denied touching the victim to the police, and actually it was one of the children who told the police, like, no, that's not what happened. And explained what happened. The state in this case is requesting a $1,500 surety bond, Your Honor. No further contact with Ms. Coverson. Stay away from the incident location. Anger awareness course. No weapons, drugs, or alcohol while out on bond. And if the court can sound for Ms. Coverson, I believe she's on the line.
All right, Ms. Coverson, I see you. Or if you wish to make a statement, please turn on your camera, raise your right hand.
I'm trying. I don't know how to do it.
Okay, please raise your right hand. Do you swear and affirm testimony you give today will be true to the best of your knowledge?
Yes.
All right. What I'm most concerned with is your desire for contact and any concerns you have for your safety. What would you like to tell me?
I am okay. He's not a risk. He's not gonna do anything. It was an accident. He's not a bad person. He needs to come home. Like, we wasn't expecting for him to get locked up. We thought they at least could have took him home. We didn't want him to get locked up. He's not a bad person.
Okay. All right. I appreciate you coming to court to make that statement. Mr. Cook?
Yes, Your Honor, my client is 39 years old. He's lived in this area his entire life. He denies the allegations that stated in the warrant. Certainly, if necessary, we would not object to a stay away or no further contact. He lives at a different location. We would object to anger management, and we would be seeking a signature bond at whatever level the court deems appropriate.
Right.
Your Honor, I would like to ask the victim some questions if the court will permit me to.
So briefly, Ms. Desiano, I think I get it. Ma'am, the state wishes to ask you very briefly some questions. Please proceed, Ms. Desiano.
Ms. Coverson, you've just stated that this entire situation was an accident.
Yes, ma'am.
Him grabbing you by the neck was an accident?
Grab me by the neck, ma'am.
Well, your child told the police that's what happened. Isn't that true?
My baby was halfway asleep. It was almost 2 o'clock in the morning. They was getting prepared time for school the next day, man.
All right.
Like we've been going through some stuff. We just lost a child recently. So like he's not any harm.
Okay.
And did you call the police in this instance?
Yes, I did. And like once before we have called before, but they took him up the street and let him to his mom's house. Like we really
I have no further questions, Your Honor. Thank you.
Okay. Defendant's going to receive a $3,000 surety bond. He is to have no contact at this time with the alleged victim. They don't share a child, do they? No.
They do not share children.
Okay. And he's stay away from that location. He's going to be reset to state all purpose. He's additionally to have no alcohol, drugs, or weapons. At the state all purpose, the issue of contact can be revisited. But for now, it'll be no contact. All right. Best of luck to you, sir. Who do we have next?
We have position number 5, Mr. Child.
All right, Mr. Child, your case is 24 CR 005799E. You're charged with 2 counts of battery and 1 count of disorderly conduct. Do you understand your rights today?
No.
All right, Ms. Hardy.
The last arrest for this defendant was June the 18th, 2024 out of Riverdale for an FTA. They have a total of 22 arrest cycles in Georgia. Misdemeanor conviction in 2014 for disorderly conduct and driving while license suspended or revoked. Nothing further to report.
Thank you, Ms. Sessiano.
Your Honor, he also has an open simple battery family violence case involving a different victim, 23 CR 002727A, that's currently in bench warrant status from a failure to appear plea in arraignment on December 4th of 2023. And I'll just note that the conviction from 2014 for the disorderly conduct was actually reduced from a simple battery as well. Your Honor, in this instance, this happened on August 18th of 2024. Officers responded to 1212 Utoy Springs Road, apartment 37 in South Fulton regarding a dispute. The victim in this case was, at the time of this incident, the defendant's girlfriend. However, it's my understanding they're no longer together after this incident. Her name is Deanna Gary. She told the police that she and her boyfriend were arguing in the car at the Shell station off Old National Highway. They were arguing over some missing money. The defendant got angry. They left. They continued to argue while they were driving, and the defendant struck her multiple times while she was driving and struck her to the point where she could not see out of her eyes because they were swollen shut. And of course, she was still driving when this happened. They then get back to their apartment. Another altercation a little time later. He struck her in the face, busting her lip, leaving multiple lacerations, and then started tearing her house apart, throwing furniture everywhere and just destroying things. The officers spoke with the defendant. He denied touching the victim, and he told the police that the victim's multiple injuries, she had a swollen face, lacerations above her eyebrows, her eye was bleeding, her eye was swollen, multiple lacerations. He said that she must have gotten those injuries from her steering wheel when she was driving because the steering wheel was vibrating. We have been in touch with Miss Gary today. She states that they were in a relationship, but not anymore. They do not live together. They have no children. She states the incident location is her residence. and sometimes the defendant would sleep over. She confirmed the events in the warrant. She stated that when he hit her in the car, she felt like she was going to crash because she could not see out of her eye. She states that her eye is still throbbing in pain and she believes that she needs to go seek medical attention. She stated this is not the first time the defendant's been aggressive toward her. There was an incident back in April when she had to call the police because he was trying to attack her and she ran into the bathroom to escape him. She's in fear of him. She's filing for a TPO today. She does not want contact and says the defendant will need a one-time law enforcement escort to retrieve his belongings. Your Honor, the risk of reoffense is high in this case. He has an open simple battery against another individual. And again, that other conviction from 2014 that was reduced from a simple battery. There's also a concern that he won't show up to court given that the open case that he has is an FTA status. And he also has another FTA from Clayton County in June. The state is requesting a split bond in this case, Your Honor, a $4,000 good bond on the batteries. That's $2,000 on each. And then a signature bond through pretrial for the disorderly conduct, the requirement that he take anger awareness courses, absolutely no contact with the victim in this case, stay away from her residence, no weapons, drugs, or alcohol while out on bond. If the court can sound for Ms. Gary.
Ms. Gary, if you wish to make a brief statement, please raise your right hand and unmute. Do you swear and affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am, I do.
All right. What I'm most concerned is desire for contact and concerns you have for your safety. What would you like to tell me?
I'm terrified. I'm here in Atlanta. I don't have any family. He attacked me on the highway doing 75 miles an hour. He don't consider my life. And I take him as a threat and I don't want no contact with him. I would drop his things off at the nearest police precinct. I don't want no third party contact or anything from him.
I appreciate you coming to court and making that statement. Mr. Cook, please proceed.
Your Honor, we're going to leave this in the discretion of the court. Thank you.
All right. Defendant is going to receive a $3,000 surety bond. It's going to be $1,000 on each count. He is to have absolutely no contact whatsoever with Ms. Gray, whether through social media, phone. If he sees her, he should turn and go in the other direction. Additionally, he stay away from her location, have no alcohol, no drugs, no weapons as a condition. Is there anything additional?
No, Your Honor.
All right. Best of luck to you, Mr. Childs. That concludes your case. Who do we have next?
Next, we have position number 6, Mr. Donald.
Mr. Donald, your case is 24 CR 005800E. You're charged with 2 counts of battery family violence. You understand your rights today?
Yes, ma'am.
All right, Ms. Hardy.
The last arrest for this defendant was February 28th, 2024 out of Fulton County for an FTA. They have a total of 5 arrest cycles in Georgia. They have 2 open cases. First one is 22 CR 005836E for DUI, giving false information to law enforcement and driving on suspended canceled registration. The second one is 22 CR 006105E. And that one is for reckless driving, open container, failure to signal lane change, and driving while license suspended or revoked. Nothing further to report.
Okay, thank you. Ms. Sessiano.
Your Honor, this incident took place on June 17th of this year. The incident location is 3097 Maple Drive. The victim in this case is DeAndre Carswell. He was in a dating relationship with the defendant and they lived together. He, on the incident date, June 17th, he went to the police station after he escaped from the defendant during a fight. He stated that the defendant was upset with him over rent money dispute of some kind. The argument escalated and the defendant punched him in the face. The parties then started fighting, and the defendant's mother at one point also intervened and tried to aid in her son's fighting, and the victim then fled the scene and sought out the police. He had swelling around his eye and a bite mark to his arm. He also had a bloody nose. We have been in touch with the victim today. He states that he no longer lives with the defendant and they are no longer in a relationship. He confirmed the events in the warrant. He states that the defendant has been violent with him in the past. This is the first time police have been involved. He stated that he's had some communication with the defendant since this incident and there has been no violence. He's not in fear and he is okay with no violent contact. Your Honor, I understand this is this defendant's first violent arrest. However, there is a concern, given what happened here and the amount of injuries to this victim and the fact that he's got 2 cases that are in bench warrant status. The state's requesting a $3,000 good bond, $1,500 on each, no further violent contact with this victim, no weapons, drugs, or alcohol out on bond.
All right, is Mr. Carswell present and wishes to make a statement? All right, hearing none, Mr. Cook.
Your Honor, we have no objection to no further violent contact. We would be asking for a signature bond to whatever level the court deems appropriate. We would object to any anger management or courses at this point.
All right, defendant is going to receive a $2,000 surety bond, $1,000 on each count. He's to have no further violent contact with the alleged victim, have no alcohol, no drugs or weapons, and he is going to state all purpose on the 3rd of September. Is there anything additional?
No, Your Honor.
All right, best of luck to you. Who do we have next?
Position number 9, Mr. Jeter.
All right, Mr. Jeter, your case is 24CR005802G. You're charged with battery family violence. You understand your right?
Yes, I do.
All right, Ms. Hardy.
This defendant does not have any history to report at this time.
All right, thank you, Ms. Essiano.
Your Honor, this incident took place on August 18th of this year. Officers responded to 7517 Rudder Circle regarding a domestic dispute. The victim in this case is the defendant's wife. Her name is Janiqua Jeter. She told the police that the husband assaulted her during an argument that began as a verbal dispute and escalated when she was trying to leave. And she described to the police that he told her not to take their vehicle and then choked her up and pushed her on the bed. The victim then slapped the defendant in the face in self-defense, and then he struck her again. The officer observed the victim to have several marks and bruises on her face and neck, consistent with being grabbed by the neck. The victim stated that her breathing was not obstructed and she did not feel like she was going to lose consciousness, but did say that she got dazed when the defendant slapped her across the face. Your Honor, our office has performed a strangulation assessment on this case. And I don't believe it meets the criteria to rise to the level of an aggravated assault based on the DA's requirements to take a case like this. However, I am concerned at what's gone on here, especially in light of what we've heard from the victim today. She states that they're married and they live together. They have 1 child together. She states that the defendant did choke her with one hand. She states that she had difficulty breathing at first, but then he loosened his grip. She stated that she did not feel like she was going to lose consciousness. And she was dizzy after he slapped her. She states that these parties have a history of this kind of conduct. She states that the defendant's in the military. She filed a report in Florida against him in 2022 when the defendant was stationed in Germany. She states that the defendant threatened to get someone to come to Georgia and kill her in that report, and she was afraid and moved to a different state as a result of that. She said there was another incident in Italy where the defendant choked her and tried to smother her by placing a pillow over her face. She states that on that incident, she did black out. She states that the defendants also choked her while she was pregnant. She is in the process of filing a TPO. She wants no contact and would like the defendant to stay away from the residence. Your Honor, I understand this is this defendant's first arrest. However, I would like to note that if there is any kind of pending criminal charges that are ongoing in the military, which is who typically has jurisdiction over these types of issues between military families, those cases are typically not reported on the NCIC. And so while I didn't see them today, it's possible that there are cases pending. In addition, the state's position is that this individual it's danger to this victim, given their long domestic violence history and the fact that she's so scared of him. At one point, she moved to a different state. There's also a risk of intimidation. This victim has relayed today what I've just relayed to the court, and it's disturbing and surprising to the state to hear that there aren't any other arrests ongoing at this point, like I said, that we know about, given that it may be something that's pending with the military. The state is requesting a $5,000 surety bond in this case, Your Honor. Absolutely no contact with this victim. Stay away from the incident location. For the defendant to enroll in DVIP or anger awareness, no weapons, drugs, or alcohol while out on bond. And if the court can sound for Ms. Jeter.
Ms. Jeter, if you wish to make a statement, please turn on your camera, raise your right hand. You are not required to make a statement, however. But if you wish to, this is your opportunity. All right, Mr. Cook.
Your Honor, my client is 26 years old. He's been in the area about 4 years. He denies the allegations as stated in the warrant. He is an active duty member of the Air Force. He's been in the Air Force since 2017. It is odd with all these alleged charges that some kind of action hasn't been taken militarily or civilly. But again, he denies the allegations as stated in the warrant. He is about to deploy to Germany in a couple of days. We would ask the court for a signature bond, whatever level the court deems appropriate, with the understanding, though, that he will be, his military obligation will take him out of the country. He has no problem with a stay away or no further contact. It is his belief that his wife is now living in Orlando, so there'd be no need for a stay away from the Rudder Circle, South Fulton address. And again, he's leaving in a few days to go out of the country. Nothing further.
All right. There was just the one count. Defendant is going to receive a $4,000 signature bond through pretrial at level 1. He is to have no contact with the alleged victim in this case, and he's going to take the 1-day anger awareness course. Additionally, he's to have no drugs, no alcohol, no weapons, and he will be reset for the notice. Is there anything additional?
No, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Next, we have position number 11, Mr. Hall.
All right. Good afternoon, Mr. Hall. Your case is 24 CR 00-58068. You're charged with criminal trespass and simple assault, family violence. Do you understand your rights?
Yes, ma'am.
All right. Ms. Hardy, please proceed.
Hey, this last arrest for this defendant was January the 8th, 2024 out of Fulton for driving while license suspended or revoked. Suspended, canceled, or revoked registration. I was not able to find the disposition in Odyssey. They have a total of 5 arrest cycles in Georgia. No convictions to report. Nothing further.
All right. Thank you, Ms. Ciano.
Your Honor, this incident took place August 18th of 2024. Officers were dispatched to 180 Ralph David Abernathy Boulevard regarding a dispute. The victim in this case is Sharday Porter. She was visibly in distress and crying when police arrived. She told the police that she was having an argument with her boyfriend of 3 years that carried over from the previous day to the incident date. She believes that her boyfriend was trying to run her off the road. She was driving. He had been chasing her through multiple streets, and when they reached the intersection of Glen Street and Cooper Street, he rammed the front end of his car with his front bumper to her front bumper, and then started throwing rocks at her while she was still in her car. The defendant denied hitting the vehicle, but did admit to throwing rocks at the defendant. Your Honor, we have been in touch with Ms. Porter today. She states that she and the defendant were in a relationship and they were living together, but she does have another place she can stay, and the parties have no children together. She confirmed the events in the warrant. She states nothing like this has ever happened before. She was afraid for her safety at the time of this incident, and at this point, she's not sure if she's currently in fear of him and does not know what kind of frame of mind he will be in due to him being arrested as a result of this incident. She stated that she wants no violent contact, and I believe she's on the line. Your Honor, he has 4 open traffic cases that I saw. And I believe that given the fact that he was following her and trying to, in the victim's words, run her off the road, that there's a risk of intimidation here. The state's requesting a $2,000 surety bond, $1,000 on each count, no further contact with this victim. I understand she's asked for no violent contact. However, it seems like she's wavering because she's not sure if she's afraid of him. So the state would ask for no contact at this time, no weapons, drugs, or alcohol while out on bond. And if the court can sound for Ms. Porter, thank you.
All right, Ms. Porter, are you present and wish to make a statement? You're not required to, however. All right, hearing none, Mr. Cook.
Your Honor, my client is 32 years old. He's lived in the area his entire life. He denies the allegations as stated in the warrant. He has no problem with no further contact or stay away. Well, actually, he lives at the 728 Cooper Street. So I don't believe the alleged victim lives there. So that should not be we would object then to the stay away from that location. We would be seeking a signature bond at perhaps level 2, nothing further, Your Honor.
All right, defendant's gonna receive a $1,500 surety bond. It's 1,000 on the simple assault, 500 on the criminal trespass and damage to property. He's to have no contact with the alleged victim and have no alcohol, drugs, or weapons. He's additionally to stay away from that location. Is there
I'm
anything?
sorry, excuse me, I wasn't able to get my camera on time when you called for me to come in.
Okay, very quickly, raise your right hand. Do you swear and affirm testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, what would you like to tell me?
I don't mind whether or not we have contact. We've never been through anything like this before, and it's more so the emotions. Like, he's not a violent person. He just, I think, was acting out of a fit of rage. But I'm not afraid of him, and I don't mind having contact with him. But I will respect whatever orders was not given. He did check on me after the fact to see if I was okay, and so he did show concern. That
Okay, I appreciate you coming to court and making that statement, Ms. Porter. All right, bond will remain as just previously said and indicated. Is there anything additional from state or defense?
Your Honor, could I ask if she lives at 728 Cooper Street or if she lives at a different location?
Do you live at that location, Ms. Porter?
No, I don't.
All right, so there's no requirement for the stay away. We'll delete that.
Thank you.
All right, best of luck to you, sir. Who do we have next?
Next we have position number 12, Mr. Jackson.
All right, Mr. Jackson, your case is 24 CR 005812J. You're charged with reckless conduct. You understand your rights?
Yes.
All right, I'm sorry, Ms. Hardy. I'm so used to Mr. Howard.
Okay, so this defendant has, their last arrest was December the 30th, 2017, out of Miami, Florida, for fleeing, attempting to elude and refusing to surrender driver's license, registration, and tag. They have a total of 7 arrest cycles out of Florida, misdemeanor conviction in 2000 for criminal trespass. Nothing further to report.
All right, thank you, Ms. Sessiano.
Your Honor, this incident happened on August 17th of this year. Officers were dispatched to the Cascade Family Skating Rink at 3335 MLK Junior Drive regarding a person who was hit by a vehicle. The victim in this case is Candace Walker. She advised that there were a lot of people outside waiting to get into the location. There were a lot of kids playing red light, green light in the street. The defendant came into the parking lot and blew his horn, ordering everyone get out of his way. And then he also said to get the kids the F out of the way. I'm not asking you, I'm telling you. And the victim in this case reasonably said, who are you talking to like that? And she also told him that there was another space for him to park over there that was not in the way of everyone. The defendant told her he didn't care, get out of his effing way, and then began to roll and then hit the victim with his car when she wouldn't move like he was demanding her to. The defendant denied hitting the victim with his vehicle and claims that she got out of the way before he put his car in drive and he was rolling his vehicle to try to get her to move. We've been in touch with Miss Walker today. She states she doesn't know the defendant. She confirmed the events. She said when he hit her, it pushed her back and she fell. She would like no contact, and I believe she's on Zoom. Your Honor, the last arrest is several years ago. However, it's a little disturbing that he hit someone with a vehicle. And I think that because this is a random situation, especially where there was a lot of kids, there's clearly an anger issue here and a public safety concern. The state's requesting a $2,500 good bond, no further contact with Ms. Walker, stay away from that skating rink, take anger awareness course or anger management course through a private party, no weapons, drugs, or alcohol while out on bond. If the court can sound for Ms. Walker.
All right, is Ms. Walker present, wishes to make a statement? Please raise your right hand. Do you swear and affirm testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, what would you like to tell me very briefly?
I don't know this man. I would like for him to stay away, seek help.
All right. Thank you. I appreciate you making that statement.
Thank you.
Mr. Cook, Mr. Cook, please proceed.
Yes, Your Honor, my client was, my client's position is he was employed by Cascade Skating Rink, and the kids and the adults were in an area, a travel way, where they should not have been. He asked them to move. There was some resistance by the alleged victim, but he denies ever hitting her with the automobile. We would be seeking, therefore, a signature bond, no more than level 2. Has no problem with no further contact with the alleged victim. As far as the stairway, it's, he'll have to figure out now if he's actually still employed by the Cascade. Okay. Okay. So, there's still an issue of whether he would still be employed there, but he certainly would not want to stay away if his employment possibilities are still available there.
All right. Defendant's going to receive $1,000 surety bond. He's to have absolutely no contact with the alleged victim. He is to stay away from that skating rink if not employed there. If he's employed, he can return. Additionally, he's to have no drugs, no alcohol, no weapons as a condition. Is there anything additional? All right. Best of luck to you, sir. Who do we have next?
Position number 13, Mr. Jinks.
All right, Mr. Jinks, your case is 24 CR 005814G. You're charged with loitering and prowling with the offense date of August 17th. You understand your rights?
Yes.
All right, Ms. Hardy.
The last arrest for this defendant was May the 28th, 2024 out of Gwinnett for criminal trespass and criminal attempt to commit a misdemeanor. They have a total of 15 arrest cycles in Georgia. Felony conviction in 2017 for criminal damage, 2008 theft by receiving, misdemeanor conviction in 2005 for criminal trespass and obstruction of law enforcement officer, 2019 possession of drug-related objects. They have 2 open cases. The first one is 23 SC 191400 for burglary. And then 24 SC 002493 for entering auto, robbery, criminal trespass, and theft by taking. Nothing further to report.
Thank you, Ms. Tessiano.
Your Honor, this incident happened August 17th of this year at 929 Ponce de Leon Place. The officer responded to this residence after the homeowner stated that she saw the defendant on her security camera in her backyard from about 5:50 in the morning and did not leave until 7:30 a.m. when she approached him. He was on camera checking her back door handle, looking through the belongings that she had in the backyard. While the police were with the victim, she identified the defendant as seeing him walk down the street and said that's who it is, and they apprehended him at that time. Your Honor, his entire criminal history are theft-related crimes. I understand at this point he didn't steal anything. However, I do think it's strange that he was in the backyard rummaging through things. The state's position is that he probably would have taken something if he saw something that he wanted. And of course, he's got those 2 open cases, and he also has an open FTA. The state's requesting a $1,000 good bond, absolutely no contact with the victim, Danielle L. Bari, the homeowner. Stay away from her residence, no weapons, drugs, or alcohol while out on bond. And if the court can sound for Ms. Bari.
Is Ms. Bari present, wishes to make a brief statement? All right, hearing none, Mr. Cook.
Your Honor, we have no objection to the conditions of the bond. However, my client is not working, has no income, and we would ask for a signature bond at whatever level the court deems appropriate.
The defendant is going to receive $1,000 surety bond. He's to have no contact with the alleged victim. Stay away from that location. No alcohol, no drugs, no weapons. Best of luck to you, sir. Who do we have next?
Position number 15, Mr. Jones.
You gotta pay some money.
Okay, Mr. Jones, your case is 24 CR 005815D. You're charged with criminal trespass. You understand your rights?
Yeah.
All right, Ms. Hardy.
The last arrest for this defendant was December 6, 2023 out of Tampa, Florida for resisting an officer. They have a total of 19 arrest cycles with arrests out of Florida and Virginia. a misdemeanor conviction in 2022 for public order charge, 2023 obstruction, 2022 CWAC charge. Also in 2023, intentional damage / destruction of property, 2024 stalking. There's felony conviction for forgery in 2016 out of Virginia. Nothing further to report.
Thank you, Ms. Desiano.
Now, this incident took place on August 18th. Defendant was arrested for being on the Castleberry Park Apartments property located at 99 Centennial Olympic Park Drive. He was previously issued a criminal trespass for that location back in July. Your Honor, I don't think this defendant has ties to this community. I'm showing that the convictions he has out of Virginia were as recent as a month or two ago. This is his first arrest in Georgia. He's got several issues in several cases from Virginia and Florida. I'd ask, or the state would ask for a $1,000 good bond based on his lack of ties and his criminal history. Stay away from the apartment complex, no weapons, drugs, or alcohol while out on bond. And if the court is considering an SOP, he has a prior trespass-like charge from Virginia, but it's not called that.
Trespass itself, though, is it?
I'm sorry?
It's not trespass. When you say trespass like, what is it? Because I didn't hear a trespass.
Damaging monument over $1,000, and I'm sorry, I can't read my writing. It's something trespass.
Okay. All right, Mr. McLean, I'm inclined to give your client a signature bond through the jail if he completely understands he should not return to that location. Any objection to signature bond through the jail?
No objection, Your Honor. I did get hold of his uncle very easily.
All right. Defendant's going to receive a $5,000 sign-on bond through the jail. He's to absolutely stay away from that location. I'm giving you a second chance, sir. They do not want you there. Don't go back to that location. He's additionally to have no drugs, no alcohol, no weapons. All right. Best of luck to you, sir. Who do we have next?
Assalamu alaikum. Next we have position number 17, Mr. Martin.
Okay. Mr. Martin, your case number is 24 CR 005819Y. You're charged with 3 counts of battery family violence. You understand your rights today?
Yes.
Ms. Hardy.
Can I say
This
something?
defendant does not have any history to report at this time.
Thank you. Ms. Allen.
Thank you, Your Honor. This is my case. This is an incident that happened on the 6th of July in 2024 at 884 Trestle Tree, TRESTLE Court, Southeast, number C. Police were called to the location where they spoke to the victim. She reported that she had been struck multiple times in the face and the head. She was seen on the scene and on body camera to have bruising to the right side of her face and scratches to her neck and her face. She reported that she and the defendant have 2 children. He had fled the location. She was able to provide his ID. The victim reported that he doesn't live there. He stays there from time to time. They do share 2 children, and that he lives with his mom somewhere in the area of Metropolitan Parkway. She reported that there were ongoing issues that they were not able to work out, and that she asked for information about a TPO, Your Honor. Domestic violence investigators reviewed the body cam and the initial statement from scene and the report. They witnessed the victim on scene reported being assaulted and the visible injuries, and they obtained warrants. I do see that this is the first arrest. We have not been able to get in touch with the victim in this case, Your Honor. The victim actually reported that she'd been grabbed by the neck in this incident and applied pressure. We would have attempted to do a strangulation assessment with her if we'd been able to get in touch with her. We called her on the listed number. We ran searches and ended up calling almost 8 different numbers to try to make contact, as well as sending an email. We have not heard back. Based on the fact that there is risk to reoffend here, Your Honor. These individuals may not live together, but they share a child, and the strangulation of an intimate partner is an escalating factor that has a high lethality rate. In addition, there are children present, according to the information in the police report and to the victim. We're not sure what level witness these children may or may not have been, but we're concerned, the state's concerned about witness intimidation and tampering. So, Your Honor, we'd ask for $2,000 surety bond on each of the counts, no contact with the victim. Her name is Titiana. That's Tytiona, Rucker, Rucker. Stay away from the location or any location where she may live, and have no contact with the children that they share, unless, of course, they're married or there's been a legitimation process, Your Honor. Thank you.
All right, is Ms. Rucker present, wishes to make a statement? All right, Mr. McLean, in light of the information before me, I'm inclined to give your client a signature bond through pretrial, require an anger management course, and have no contact whatsoever with the alleged victim. Is there any objection?
That sounds appropriate.
I'm sorry, there was a stay away requested, Ms. Ellen, correct?
Yes, Your Honor, we are requesting that.
Okay. Defendant's going to receive a $6,000 SOB through pretrial, $2,000 each count. He's to have no contact with Ms. Rucker, stay away from that location. He can return one time with a member of law enforcement to get any items. Additionally, he's to have no drugs, no alcohol, no weapons. He's going to take the 1-day anger awareness course, and his signature bond through pretrial will be at level 1. Is there anything additional?
Nothing.
All right. Best of luck to you, sir. Who do we have next?
All right, thank you.
We have position number 19, Mr. Minifield.
All right, good afternoon. Your case is 24 CR 005803E. You're charged with battery. Do you understand your rights? All right. Ms. Hardy.
The last arrest for this defendant was March the 22nd, 2024 out of East Point for stalking and criminal damage to property. They have a total of 26 arrest cycles, with arrests out of Georgia and Alabama. Felony conviction in 2019 for printing, executing negotiated checks known to be in error or fictitious. They have a misdemeanor conviction in 2023 for forgery. 2019, possession of marijuana less than an ounce and tampering with evidence. There's an open case in Fulton County for entering auto, possession of marijuana less than an ounce. That number is 19 SC 165613. And there also appears to be a hold out of Cedartown for a probation violation. Nothing further to report.
All right. Ms. Allen, please proceed.
Thank you, Your Honor. This is an incident on a stranger. It occurred at 3:15 in the afternoon on the 15th of July at 2451 Old National Highway in College Park. The victim, his name is Hemant, Hemant, Kothar, Kothekar. This is a hotel where the defendant was renting room 147. He was seen on the premises walking around without a shirt on. The front desk clerk, Mr. Kothar, instructed him to put a shirt on. And in response, the defendant struck him in the left side of his face, causing bruising. This incident was captured on surveillance, Your Honor. There was a fresh laceration and bruising on the left side of the victim's face. Police went to the room that he'd rented out, 147, but were unable to locate him, and a warrant was obtained. So this is a stranger on stranger violence. This is a community safety issue. There's a significant history for this gentleman, including an incident just this March and an open PI case for damage to property and stalking. Your Honor, we'd be asking for a $2,000 surety bond to stay away from the location at 2451 Old National. Have absolutely no contact with Mr. Kothar, Kothekar, no drugs, alcohol, or weapons while on bond. Thank you. And we have been in touch with the victim, Your Honor. He did confirm the events in the warrant. He was not able to attend today.
They NOD some of his stuff, but not all.
We'll still sound. Is Mr. Coulthard present or wishes to make a statement? Okay. All right. Mr. Cook, or is it Mr. McLean?
It's mine, Your Honor. Thank you.
All right, please proceed.
Your Honor, my client is local. He has a high school education. He works in moving furniture. He won't have any trouble making court. It was easy to establish his mailing address, an apartment number. We would ask the court to consider a signature bond, and if not a signature bond, a very low surety bond.
Okay, defendant's gonna receive a $2,000 surety bond. He's to have no contact with the alleged victim, stay away from that location, have no alcohol, no drugs, no weapons. And as a reminder, he'll be reset to state all purpose on the 3rd of September. All right, who do we have next?
Position number 21, Mr. Strozen.
I ain't finished. I got a question.
Okay, you should ask your attorney. That's the best place. I don't want you to infringe upon your right to remain silent.
I need you to hear this.
Why don't you ask your attorney and let your attorney ask me?
We can go into a break all after court.
What is your question about the bond?
Nah.
Okay, well, I think any other question you have, you should perhaps speak to your attorney. What is your
I need you to hear it. You're the one that read it out.
What's your question? Very quickly.
Those charges that was read out loud, all those cases are closed. They're all closed. So I don't understand,
So is there a question? What's the question?
That's the question.
That's not a question. That was a statement. I think we have, what you should do is speak with your attorney following this information. The bond will remain as said, all right? Best of luck to you, sir.
So why are you reading them out then?
Okay. Mr. McLean or your attorney will speak with you further. Mr. Strozier, please come forward. Your case is 24CR005807C. You're charged with fleeing and eluding and obstruction. Do you understand your rights? Ms. Hardy, please proceed.
Last arrest for this defendant was November 22nd, 2023, out of Fulton County for theft by taking and criminal damage. That case was dismissed. They have a total of 42 arrest cycles, arrests out of Georgia and Alabama, a felony conviction in 2008 for possession of controlled substance. Also in 2008, terroristic threats and acts. 2019, possession of Schedule II controlled substance. Misdemeanor conviction in 2019 for driving while license suspended or revoked. 2008 criminal trespass. 2004 hindering a call for 911 and simple battery family violence. There appears to be a hold out of Andalusia, Alabama for an FTA. And the date of the warrant is 5/16/2024. Nothing further to report.
All right, thank you, Ms. Allen.
Thank you, Your Honor. This is an incident that has actually two dates. On the 10th of July, 2024, at about 3 p.m., police were in the location of the 2700 Palm Drive block in East Point, where they conducted a traffic stop, or attempted to, of this defendant on a moped. He was driving without a helmet, and he was seen to run a stop sign at the intersection of Sylvan and Cleveland. He stopped as if he was going to stop and then proceeded to flee on his moped going south on Palm. On the 14th of August, the same officer, Officer Harrison, saw the defendant again on the block of 2700 area of Palm. He was getting out of a pickup truck there at the location and recognized by the officer. Officer parked his vehicle, and the defendant saw him doing this and immediately fled on foot. While fleeing on foot, the defendant yelled to the officer, "You're going to have to work for this. I'm not going to stop," and led the officer on a long foot chase. He was tased and actually pulled one of the taser prongs out of his back and continued to run, climbed over a truck, and it was a lengthy pursuit, Your Honor. So that's the basis of the obstruction charge. He was seen to have outstanding warrants out of Covington, Georgia. Your Honor, this defendant has a failure to appear status in 21 CR 001764. That's an obstruction and false information case here in state court. He's got prior convictions in state court for fleeing and obstruction similar to this case, Your Honor. We'd ask for a $2,000 surety bond and no drugs, alcohol, and weapons while on bond. This gentleman has a risk to reoffend. He's got an open similar case, and he has not come to court previously. Thank you.
All right. Mr. McLean?
Your Honor, let me make sure my mute's off.
We can hear you. It's off.
Okay. He is local. His address is local. He was born here. His relatives are here. His girlfriend's here. He has been attempting to obtain employment recently, Your Honor. The matter in Covington is a minor traffic charge. No, excuse me, a minor theft charge. He says it should be taken care of extremely quickly. He's asking the court to consider giving him a signature bond to go take care of the Covington matter.
All right, defendant's going to receive $1,000 surety bond, 500 each count. He's to have no weapons, drugs, or alcohol as a condition. Anything additional?
Nothing.
All right, best of luck to you, sir. Who we have next?
Next, we have position number 24, Mr. Williams.
All right, Mr. Williams, your case is 24 CR 005811A. You're charged with 2 counts of battery family violence. You understand your rights?
Yes, ma'am.
All right, Ms. Hardy.
Last arrest for this defendant was May 20th, 2021, out of Fulton for driving while license suspended or revoked. They have a total of 16 arrest cycles in Georgia. Felony conviction in 1990 for aggravated assault. They received first offender treatment, but no seal date was listed. 1998 aggravated assault, possession of a firearm during the commission of a felony and by a convicted felon. Misdemeanor conviction in 97 for maintaining a disorderly house. Nothing further to report.
All right, thank you, Ms. Allen.
Thank you, Your Honor. That's my case. This is an incident actually from September of 2023. This is a delayed arrest. The criminal history, as I read it, includes a 1997 conviction out of Clayton County for kidnapping and aggravated assault, which would make him restricted. He also, of note, has a battery family violence case here in state court from 2021 that was recently dismissed. It was against his niece, who he struck in front of his mother, who was a witness. I believe the victims were unavailable to testify, and we had to dismiss that case. This case occurred obviously a year ago. Police were called to the location at 3408 MLK Drive, Southwest at about 6:30 a.m. The victim, Chelsea Stegall, Stegal, reported that she had been assaulted by the defendant who lived with her. She reported that she had been punched in the face, bit on the arm and her chest, and punched to her face, which caused bruising, a busted lip, and bite marks. She reported that she'd been on the phone with a friend. When she walked over to the sofa, the defendant grabbed her and proceeded to try to pull her pants down. When she resisted that attempt, that's when he assaulted her, punching in her face several times. She grabbed him in his genital area to get away from him. She then called her next door neighbor and disclosed what had just happened. Conveniently, the defendant walked over to the next door neighbor's house. Her name is Miss Furby, Furby. She reported that the defendant knocked on her door and came inside. He was visibly intoxicated, and he laid down on her couch. She removed him from her apartment and went next door where she saw the victim and noted to police that she was horrified to see the injuries on the victim's face. The defendant had fled the location. Warrants were taken out. Both the witness on the scene and the victim identified the defendant. We're asking for a $5,000 surety bond, Your Honor. Stay away from the location or any location where Mrs. Stegall may live. Have no contact with Miss Furby. Her first name is Marvetta, Marvetta, as well. No contact with the witness or the victim. No drugs, alcohol, or weapons. And that's it, Your Honor.
All right, is Ms. Stegall on the line?
Yeah.
Yeah.
All right, hearing none, Mr. McLean?
Your Honor, I don't have a copy on me of that page of the actual calendar. What's the charge? Is it battery or battery family violence?
It's 2 counts battery family violence and 1 count simple assault family violence for 3 charges.
I did hear the state say that they lived together, but I just didn't see that in the police report. At any rate, Your Honor, he has worked as a forklift operator for the last 15 years. Currently, he is laid off and will have some financial problems, but he is applying for another job while he's laid off from the forklifting job. But given his experience, he believes he will fairly soon get another forklifting job. He has an address which is separate from hers in a 30331 area code. He's more local. He's born in Griffin, but he's essentially an Atlanta person, and there shouldn't be problems with his making court, Your Honor. We would ask the court to consider a signature bond or a very low surety bond.
All right, defendant's going to receive a $2,500 surety bond. It's going to be $1,000 on the battery family violence, $1,000 on the second count of battery family violence, and $500 on the simple assault. He's to have no contact with Ms. Siegel or the other witness in this case. Additionally, he's to have no drugs, alcohol, or weapons, and he's to stay away from that location. And he will be reset to state all purpose on the 3rd of September. Is there anything additional?
Nothing.
All right, best of luck to you, sir. Who do we have next?
We have Mr. Rawton, but he's not on the calendar.
Instead of some of the charges were NOD'd, I'm not sure if they were all NOD'd. Maybe that was my just reading of the notice.
Who is it?
Thomas Broughton, Broughton.
Yeah, his misdemeanor case has been NOD'd. I believe he had some felony matters that were holding him.
Okay, then I misread it. Thank you. Sorry.
All right, is that the entire calendar? No,
we have a couple waivers. Position number 2.
Thank you, Ms. Jessiana.
And 2, 7, and 23 are waivers?
7, yeah.
7 is a waiver, yes.
What about 23?
23, yes. 23 is hold on 1 second.
I think it's 23 Varner.
I think so.
Yes, yeah.
I heard he was a refusal.
Right, he refused.
Well, 2 is a waiver as well.
2 is a waiver, 7 is a waiver, 23 is a reset to tomorrow.
Yeah, we'll try again with 23 tomorrow. He just refused to talk to anybody.
Okay. See if you can get him to waive tomorrow if you can, please.
Okay.
All right. Let's see. Let's take up the first waive case. Damian Bennett, 24 CR 005796G. He's charged with criminal trespass. Ms. Hardy, can I have that history?
There's a total of 30 arrest cycles out of Georgia. Last arrest was October 26, 2023 out of Fulton for a probation violation. Felony conviction in 2000 for fraud, 2008 aggravated assault, 2018 interference with emergency medical professionals, misdemeanor conviction, public indecency in 2020, criminal trespass in 2017 and 2019. Simple battery in 2017 and 2016. Nothing further to report.
All right, thank you, Ms. Desiano.
Your Honor, this defendant was at Emory University Hospital Midtown as a patient. He was discharged and then he refused to leave the hospital. The state's requesting a signature bond through pretrial. He's got prior convictions for trespass and a stay away from the hospital unless he's receiving treatment. No weapons, drugs, or alcohol while on bond.
Mr. McLean, do you object to a signature bond through pretrial at level 1?
That's fine, Your Honor.
All right, defendant is going to receive a $2,000 signature bond through pretrial at level 1. If it needs to be per judge, it can be per judge. He's to stay away from that hospital unless receiving treatment, have no alcohol, drugs, or weapons. All right, let's take the next wave case, position 7. That is 24 CR 00 5801C, the case of Sundance Duale, where he's charged with simple battery against the police and theft of service. Ms. Hardy?
Last arrest was July 24th, 2024 out of Roswell for criminal damage to property. That's their only arrest, and it's open under 24 PI 005313. Nothing further.
All right,
And Judge, in that open case, there's also a theft by taking and a criminal trespass count as well. In this case, she went to the Wicked Wolf Bar, ordered a shot of Don Julio, and walked out without paying for it. The total bill was $24.87. And then when the officer was trying to get her in the patrol car, she was repeatedly spitting on him. The state's asking for a split bond in this case, an SOB through pretrial on the theft, and a $1,000 surety bond on the I'm sorry, no, I crossed through that because she's got that open theft. Never mind. Let's do a $500 good bond on the theft, a $1,000 good bond on the battery, and then a stay away from the Wicked Wolf, no weapons, drugs, or alcohol while out on bond.
okay, Mr. Cook?
We have no objection to stay away, Your Honor. We would be seeking an SOB through the charges.
Okay, defendant's gonna receive $1,000 surety bond, 500 each count. She's to stay away from that location, have no further violent contact with the officer in question, have no alcohol, no drugs, no weapons. All right, is there anything additional?
No, Your Honor.
All right, can we review the calendar, please?
Your Honor, if we might revisit Mr. Jeter, position 9, just quickly.
If we can go back to Ms. Dooley, what was the, this was a signature bond through pretrial or the jail judge?
No, it was a surety.
Oh, for Dooley?
Yes,
Oh, okay.
500 each count.
Thank you.
I'm sorry, what are we revisiting, Ms. Allen?
On Mr. Jeter, that's the gentleman who defense counsel said he's got military orders to leave the country in a few days.
Uh-huh.
In order for him to be able to do that, he's going to have to show his orders to pretrial, and I believe Your Honor has to indicate that he is allowed to phone in.
Okay, so we can add that to the order.
Yeah, thank you.
Thank you. All right, let's review the calendar.
Who was that?
We're gonna add to the order for Jeter that he can, he has permission to appear by phone or Zoom. But I think typically once you show
orders to pretrial, is that correct, Ms. Allen? He must show his orders to pretrial.
Yes.
Yes.
Okay, that's it. Sure, no problem.
Otherwise, I have orders too, and I gotta go.
Me too.
I do too, but I don't know.
We're far away from here.
Position number 1 was a $3,000 good bond reset, SAP. Position number 2 was a $2,000 signature bond through pretrial, level 1. 3, $8,000 good bond reset, SAP. 4, $4,000 good bond reset, SAP. 5, $3,000 good bond reset, SAP. 6, $2,000 good bond reset, SAP. 7 was a $1,000 good bond reset, SAP. 8, $3,000 signature bond through pretrial, level 1. 9 was a $4,000 signature bond through pretrial, level 1. 10, $2,500 signature bond through pretrial, level 1. 11 was a $1,500 good bond reset, SAP. 12, $1,000 good bond reset, SAP. 13, $1,000 reset, SAP, good bond. 14 was a $2,000 signature bond through pretrial, level 1. 15 is a $5,000 signature bond through the jail. 16 was a $1,500 good bond reset, SAP. 17, $6,000 signature bond through pretrial, level 1. 18 was a $6,000 split bond, 3,000 good. 3,000 signature bond through the jail, reset, SAP. 19, $2,000 good bond, reset, SAP. 20, $2,000 good bond, reset, SAP. 11 was a $1,000 good bond, reset, SAP. 22, $1,000 good bond, reset, SAP. 23 is reset for tomorrow's C calendar. 24 was a $2,500 good bond, reset, SAP. And 25 was a $1,500 good bond, reset, SAP.
Can you tell me what the numbers amounts? I'm sorry, words are hard for number 11 and 12.
Uh-oh, I don't know that I can. I hope Ms. Strong can.
I'm sorry, what was the question?
What's the amount for number 11 and number 12?
11 was a $1,500 good bond and 12 was a $1,000 good bond.
Thank you, ma'am. You go real fast.
All right, we will be in recess until tomorrow's SCA calendar. Take care, everyone.
How old is that beauty?
How old are you, hon?
7. Oh, this is Mother-Daughter Day.
It is. That's
Oh,
how
okay, I absolutely love it.
we have to roll that way sometimes, Miss Holly.
I truly understand. Both of you have beautiful daughters.
My twins come home at 2:30. They walk home from elementary school and they have to be quiet while I'm in here yelling about stuff.
Oh, okay. Very good.
Mine usually is sitting at my feet, tapping me. Are you done yet? Are you done yet?
Can we watch Napoleon Dynamite? Can I have some cookies? When's Daddy gonna come home?
Wow.
Sounds like my life. All right, y'all. Take care. Looking forward.
Take care, everybody.
Okay,
Bye-bye.
bye.